Good evening, I'm Pinky Webb. Tonight we ask the questions, we tackle the issues, we clarify matters, and we get on point. The new set of Senator judges have yet to take their oaths for the impeachment trial of Vice President Sara Duterte. Senate Impeachment Court spokesperson Regie Tongol says it is important to wait for the opening of the 20th session of Congress to ensure there will be no issue as to whom the senator judges will take their oaths. As of now, the ball remains in the hands of the House of Representatives as it has yet to submit the new lineup of prosecutors and the second certification asked by the impeachment court that they are willing to pursue the complaint in the 20th Congress. Let's get on point with the former Dean of the FEU Institute of Law, Attorney Mel Sta. Dean, I know I've spoken to you in the past. First time I'm seeing you. Maraming salamat po sa inyong oras.
My pleasure, Pinky.
All right, so the impeachment court is basically waiting. There is parang may receivable. May hinihintay silang dalawang bagay.
Dami.
Opo, yung isa, yung una is the reappointment of the House prosecutors because pumasok na po yung 20th Congress. And the second is the certification from the 20th Congress that they will pursue, are willing to pursue the impeachment from the 19th Congress. Let's talk about the first. Ito pong reappointment of the House Prosecution Panel. Why do you think this has not happened just yet?
Well, hindi natin alam actually, pero napakadaling gawin yan. It's very easy to do that, no? Because the congressmen and women have already taken their oath, no? The managers can be easily appointed, and people are volunteering for the job, so they just have to do it. It will take, around 30 minutes, 5 minutes to do that. But I don't know what's taking that too long, no?
Yeah. You know, I had Congresswoman Laila de Lima yesterday. And I asked her, nagkaroon na ba ng meeting? Meron na bang pag-uusap? Bakit wala pa yung reappointment of Congresswoman Laila and Congressman Shell?
Yes.
Wala pa. Sabi niya, as far as she's concerned, they are part of the team, but there's been no meeting or reappointment of the House prosecution team just yet. So I kept asking her, bakit ho kaya? But there was really no concrete answer to that.
Well, hindi natin talaga malalaman yan, pero napakadaling gawin. And I'm sure gagawin nila yun. To be consistent with their advocacy, no? Their advocacy is to pursue this impeachment. So siguro within the next few days, malalaman na natin kung sino itong mga tinatawag na managers or prosecutors.
But the thing is, they can do it already kasi pumasok na yung 20th Congress nung Monday at 12 noon, di ho ba?
Yes.
That's why, again, it begs that question. All right, so that's for them to answer. Let's look at the second one. Certification from the 20th Congress that they are willing to pursue the impeachment from the 19th Congress. The question here is there anything wrong? Is there any repercussion if the House submits this certification?
Technically, that certification, in my opinion, is not needed. Because by jurisprudence, Congress cannot have a gap. Ang Kongreso natin hindi pwedeng mawala ng congressman. Kaya nga parating yan, it's a continuing thing, it's a continuum. Pero okay, just to settle this amicably, pwede namang ibigay ka agad-agad yan. Walang problema. Walang problema. Ito, we certified that we want to have the impeachment proceed and we adopt the articles on impeachment. No problem with that. Technically, it's not needed, but for purposes of the smooth flow of the proceeding, sige na, ibigay na para matapos na.
You don't see any repercussions in submitting this certification?
Hindi naman. Sa tingin ko, wala. It's just a certification that we will pursue the we will pursue as managers and prosecutors in that impeachment trial with a caveat, for example. Because all certification can be qualified. It could be qualified, for example, by saying this is not an admission that the 19th Congress has ceased and it also ceased its representation as to the impeachment. We continue to assert that this is it's a continuing body, pwede nang sabihin yan, and this remedy or this mode of acceding to your request is merely for courtesy purposes, if only to speed up the trial.
The question, though, Dean, is that there was an interview by, I think it was ANC, kay Congressman Shell Diokno. And he was asked at some point during the interview that could this be a problem from the 19th to the 20th Congress? And then he mentioned the word trap or concern. This could be a concern dahil pwede daw, sa pagkaintindi ko, pumasok dito yung supposed violation, or alleged rather, hindi supposed, alleged violation of the one-year bar rule against impeachable officers. What do you think of that?
Hindi naman. Sa tingin ko, hindi naman. Kasi yung one-year bar rule, tapos na yun eh. We are already in the trial. The one-year bar rule is the initiation of the impeachment investigation. And initiation, iyan yung filing and referral. Tapos na yun. We are now in the trial stage. Kasi sa Constitution natin, it's very, 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 very brief, short. No? It says, initiate, investigate, transmit, trial, and decide. So nandun na tayo sa trial. Tapos na tayo dun sa pangamba ni Shell Diokno, para sa akin.
That's your opinion. But this has been questioned, at least the jurisdiction of the impeachment court, because there are supposed concerns or problems with the 4 impeachment complaints that were lodged before the House. Again, meron pong una, December 2, the second was December 4, third one was December 19, and the last one was February 5. Nakapaloob po sa Constitution, Article 11, that this has to be included in the order of business within 10 session days, to which I think it is believed that this is being questioned at the moment.
Okay. Linawin natin. Let's make clear what initiation means. No? Initiation means 2 things. The filing and the referral. So even if you file 1,000 complaints, but it has not yet been referred, there is no initiation. Okay? So that's the idea of initiation. So ngayon, sinasabi nila yung time element, there was an intentional delay. No? But that delay cannot, for me, that delay cannot trump the substance of the law. The law says, basta't ni-refer mo, yun ang initiation. Kung madaming nagpa-file and it takes time, well, that's life.
But it's in the Constitution. It should be calendared within 10 session days. Aren't you worried about that?
It should be calendared within 10 session days. The calendar
should be included in the order of business rather within 10 session days.
But I'm not worried about that because that is a matter of procedure, and the procedure is limited by the substance of the law. No? Ang law natin is very clear kasi. Ang law natin is just initiation, investigation, trial, and decision. Anything below that are just minute procedural matters which can be waived. No?
Could it be considered as technicalities? Pasok po ba dyan yung
technicality, but not enough. Not enough to destroy the impeachment process. Not enough to destroy. There are technicalities that are in a way substantial. There are technicalities that are not. Diba? So this is not. If ever this is a technicality, it is a minor technicality that will not deviate from the substance of this process.
If that is the line of thinking that we will pursue, then why did the impeachment court ask for 2 certifications from the House prosecution panel? The first of which is that they did not violate the one-year bar rule. And then the second, again, as we mentioned a while ago, is a certification from the 20th Congress that they're willing to pursue what the 19th Congress did.
Okay. They asked that for whatever reason they have. But let us begin with what is in the law. Is that required? Well, that is not required. For as long as the House of Representatives has finished its investigation and has transmitted the articles of impeachment, it's over. That's finished. No? And the Senate must give due respect to the House of Representatives. Number 2, the Senate is not an appeal court. They cannot question the wisdom of their co-equal body. No? And so that therefore, hindi na talaga kailangan yung 2 certifications yun. But again, if only to speed up the process, there is nothing for the House to say, sige, gagawin na namin para matapos na. So no technicality at all. So, iyan ang position ng Senate, which creates a little some questions, but actually it's more apparent than real when you look at the procedure and when you look at their very own rules. Wala namang ganun.
So what was your reaction when Senator Alan Peter Cayetano had moved to actually return the articles of impeachment to the House pending these two certifications?
Well, my reaction was that it was an interference. It was a disruption. It was a disturbance to the trial process. Remember, a trial is an ongoing continuity. It is presentation of evidence and reception of evidence. That's a trial. When you put up a motion, any kind of motion, just like in an ordinary court, basta nagtatrial kayo, mag-file ka lang ng motion for postponement, interrupted na eh. A motion is not included in the concept of a trial. And even in our rules of court, there is a separate provision on motion and there is a separate provision on trial. So that therefore, when he says, I move to remand the case to the House of Representatives, it is actually a disruption already, an interference to the mandate of the Constitution. So it is unconstitutional for me.
Unconstitutional.
Yes.
What the 18 senators voted for or approved this particular motion, to you that was unconstitutional?
Well, in my opinion, yes. Because, they cannot say that here in the Senate, our power is absolute. They cannot say that. Because in a constitutional government, and in a constitutional democracy, the mere notion of power already demands limitations. Because if there are no limits, the road to abuse is a free highway.
Infinite.
Infinite na talaga. And the impeachment process is a mandate of the Constitution. Hindi mo makikita yan sa rules of court. You can only see that in the Constitution. And therefore, the impeachment process is a constitutional case with boundaries set by the Constitution. And napaka-brief ng Constitution. Initiate, investigate, try, and decide. Nothing more, nothing less. There is no leeway. There is no leeway. That provision of the Constitution, those operative words, set the procedural and substantial limits of their power.
Just a quick question on that. If it is, for example, sir, proven that the premise, which is the articles of impeachment, was illegally, was that the right word, was not done properly. It was illegal. Sabihin po natin, for many reasons, hindi natuloy po yung calendared within 10, included in the order of business within 10 session days, or pumasok, kunwari po si one-year bar rule. If the premise was wrong, can the impeachment court question that?
Very good question, Pinky. In my opinion, they cannot. Because
Whether wrong or right, walang
whether
karapatan ng
wrong
impeachment
or right,
court.
what they should do, they should be the one to go up to the Supreme Court because they are not the appellate court of the House of Representatives. They are not the monitoring body to see whether the House of Representatives did what is correct. The House of Representatives is a body in itself, it's a co-equal body. They have their own obligation, they have their own tasks, they have their own rules. They are supreme in their own rules. What they finished must be respected by the Senate.
So moving forward, right now it's we have about maybe 3 weeks before the President's State of the Nation address and before mag-formal opening na po ang 20th Congress. That's on July 28. July 28. So we have about 3 weeks now. What can happen between now and then?
Well, okay. They could start the process. They could start the process without waiting for the SONA. They could start the process and pleadings have already been filed. All written documents have already been filed with the impeachment court. And the next step already is for the appearance of Vice President Sara Duterte to be asked the question, are you guilty or not guilty?
Would that form part of the pre-trial or trial na po yan? Trial proper na
Yes,
po yan? I see.
it will come before the preliminary conference. So, pleadings have been filed. The next step is the presentation of the respondent. And the next step is the a preliminary conference.
And the presentation of the prosecution.
Then, no, after the preliminary conference, then the presentation of evidence.
Okay.
And then after the presentation of evidence, well, the closing remarks, and then the decision. So we are at the stage now where the next step is for Vice President Sara Duterte to appear before the impeachment trial court and to be asked.
But
guilty or
Dean,
not guilty.
the impeachment court has to, the 12 new senator judges need to take their oaths first before that can happen.
Oh yes, definitely.
Opo.
Oo.
So-
But that can take any time if they want.
Yeah. Ang sinasabi ho kasi ng spokesperson ng Senado on this is that July 28 is the President's State of the Nation address. Possibly they will vote for their Senate President, rather. And then July 29 would probably the time that the 12 senators will take their oaths as senator judges, and then it starts from there. So in my mind, it appears that nothing will happen from now until January 28 or 29.
Well, if that is the case, if they will follow that procedure, then yeah, so be it. Correct. Correct, because but if the new judges will take their oath now,
Sooner, yeah.
then the process can go on. Actually.
But who can manifest that? Who can ask for that? Can that be asked by anybody from the impeachment court? Can the House prosecution panel seek that or have a pleading on that or a manifestation on that?
The senators themselves have to do that. We already want to take our oath. That's the only thing that can be done. Of course, the managers, they could only request. But it's the new senators who could say that.
Quickly before we go on a break, but don't you need a Senate president first to be able to, or a presiding officer to decide on that?
An administrating officer can be the Senate president now.
I see.
So for as long as he's an administrative officer who could administer oath, that's enough.
All right, we need to take a short break. We'll be back with the former dean of the FEU Institute of Law, Attorney Mel Sta. Stay tuned. This is On Point. You're watching On Point, still with us, the former dean of the FEU Institute of Law, Attorney Mel Sta. Question on jurisdiction. Should the issue on jurisdiction first be resolved before an impeachment trial begins? I ask that because there was a statement made by Senator Alan Peter Cayetano. Let's listen to that particular statement.
Ipalatag yung ang unahin mo parati ay jurisdiction. Ano ba ang basihan ni Senator Bato nung sinabi niyang i-dismiss? Kasi daw unconstitutional kasi more than one impeachment filed in a year. So kahit saan korte, bago mo ipalatag yung ebidensya, titignan mo muna may jurisdiction ba yung korte na yan o hindi.
Go ahead, Dean.
Ito ang sagot ko dyan. Basta abogado, alam mo kung anong dalawang klaseng jurisdiction. Jurisdiction over the subject matter and jurisdiction over the subject. Basta't sinabi mong jurisdiction over the subject matter, anong issue? Impeachment. We all know it's only the Senate who could try and decide. So nung nakakuha na sila nung articles of impeachment, jurisdiction no February 5 has already attached. They have the right to try and decide it. Jurisdiction over the subject, wala nang kaduda-duda. Natanggap na ng Office of the President, Office of the Vice President, yung articles of impeachment and the so-called summons and order to answer. She answered, reply has already been filed. Sa litigation yan, issues have already been joined. Ngayon, the issue of constitutionality, sabi niya, constitutional ba ito? Baka more than once ang final during...
Right.
Pwede bang dinggin ito sa loob ng impeachment trial? Iyan ang limitasyon na ginagawa ng ating konstitusyon. Sabi ng konstitusyon, wala kayong gagawin kundi mag-try at mag-decide. Ngayon.
The Senate shall try and decide.
Ngayon, kung may question si Senator Bato sa jurisdiction, hindi ang Senate ang magdi-decide nun. Aakyat siya sa Korte Suprema. Doon siya aakyat. At kung hindi magbigay ng injunction ng Korte Suprema, tuloy-tuloy ang kaso. So ibig sabihin, mali ang hinainan ng motion to dismiss. Sapagkat yung motion hindi kasama sa obligasyon ng Senado.
So you're saying mali po ang naging sagot, yung answer ni Vice President Sara Duterte's camp to dismiss the impeachment case filed against her, because yun po ang kanilang sagot. And of course, there are also petitions before the Supreme Court regarding this.
Nabasa ko nga yung sagot nila, no? Ang una nilang sinasabi, ito ngang walang ultimate facts. Pero kung babasahin mo naman yung articles from 1 to 7, tad-tad ng facts, no? So, sinasabi rin nila the rule on one impeachment. Pero medyo madaling sagutin yun kasi ito yung filing and referral For as long as hindi magkaakibat yung dalawang yun, walang initiation. Yung pangatlo naman, ito yung
19th to 20th Congress.
hindi tatawid.
Right.
Pero meron ng mga desisyon ng Korte Suprema. Ang legislature natin has three function actually. Legislative, impeachment, ang Senate pala, legislative, impeachment, and electoral tribunal.
The HRET or the
Ngayon
Senate
sabi ng
Electoral
Korte
Tribunal.
Suprema, not because the legislative nature of Congress has terminated, the two others will terminate. It cannot be because it is a continuing body. And so therefore, the legislative nature has terminated, but the quasi-judicial, which is impeachment, will go on.
You know what, come to think of it, Dean, I do recall, if I'm not mistaken, even Senate President Chis Escudero saying that, using the Senate Electoral Tribunal as an example of the continuing body that, everything continues even if you are on break or magkaroon po ng mga bakasyon or susunod na kongreso. But there's also that notion that if there is a manifestation filed before the impeachment court, that they can vote on that, and that if you get a simple majority, the case can be dismissed. There's another soundbite from Senator Alan Peter Cayetano. Let's bring that in.
Ang hindi klaro kasi in this case, hindi nila pinagalaw yung tatlo So ang question, did they violate their own rules?
Alright, so basically that's also part of that. Yun na nga yung pinag-uusapan natin kanina. Nagkaroon ba ng pagkukulang, pagkakamali ang House doon sa pagpasa ng kanilang fourth impeachment complaint or pag-transmit nito? So the question there, Dean, is that by a simple majority, from what we understand, this can be dismissed. The case can be dismissed. Go ahead.
Then it boils down to the nature of the manifestation or motion that was introduced.
Okay.
If you will look at the Senate rules themselves, dalawa lang klaseng motion na pwedeng pag-usapan. Isang motion in relation to the Senate procedure at motion immediately relating to the trial, including determination as to the relevancy of evidence. Sabi nung batas nila, any motion in relation to Senate procedure and in relation immediately relating to trial can be accepted.
So just procedure and trial?
Correct.
Okay.
That is correct. So therefore, basta isang ebidensya, admissible ba yan o hindi? Magmo-motion ngayon. Let's put it on the plenary kung a-admit natin o hindi. But the trial is not negated. Yun lang ang dalawang motion na pwede nila. Sa rules nila,
Let me give you an example on that before you go to the trial. Sabi mo procedure or trial. Dito ho ba sa procedure, ang sinasabi niyo, pwedeng pumasok yung issue ng pagbubukas ng, let's say, bank documents, or let's say the case of former President Joseph Estrada, the case of the second envelope. Dito ho ba sa procedure yung pwede silang bumoto and by a simple majority pwedeng buksan ang envelope o hindi?
pasok na pasok yan.
I see.
Because you are now talking about evidence. There is a difference between ultimate facts and evidentiary facts. Yung articles of impeachment, ultimate facts lang yon. Alam mo, for example, sasabihin mo, there is a contract that was entered into between this person to kill that person. Sasabihin ng kabila, o anong contract yan? Written ba yan o oral? Linawin nyo. Yung whether written or oral, evidentiary fact na yon. Trial na yon. Pero yung ultimate fact na sabi mo na, may kontrata. Yung sinasabi mong envelope, talagang trial yon because it is evidence. So, pasok na pasok yun.
I see. And then you said, was that, sabi mo, procedure or trial?
Yes.
Ano po yung sa trial part?
Ito na yun. Ito na yung sinasabi mong tama, admissible ba evidence? Relevant
see.
ba itong evidence? Diba? Yung ano naman, yung sa procedure, o ano mauunahin natin? Uunahin ba natin ang preliminary conference bago pa attended dito si Vice President
So, pa yung
Sara?
proseso.
Yes, yung proseso,
impeachment.
pero hindi mo pinuputol ang paglilitis.
Here's siguro also maybe just a summary on the petitions before the Supreme Court. I understand that there's a petition on questioning the continuity from the 19th to the 20th Congress that has not been obviously decided. Also, the question on the one-year bar rule, hindi ho ba? And there's also a question on forthwith. If I recall, there was also a petition filed before the Supreme Court trying to understand ano ho ba at kailan ho ba dapat ginagamit at kailan dapat inuumpisa ng trial kapag meron pong nakasulat na the Senate shall forthwith proceed with trial, hindi ho ba? So none of the petitions filed before the Supreme Court have been decided upon or decided on.
Yes.
While they do not decide on that, what should happen?
The trial should continue because they are co-equal bodies. No? So the Supreme Court, the three departments, executive, legislative, and judiciary, is supreme in their own right. No? Yung Supreme Court, naghain ng petition dyan. Kung gustong pigilin ng Supreme Court, hihilingan Supreme Court, it is requested of you to please stop momentarily while we are deciding this case.
TRO.
Yes, TRO. But yun, request yun. Because the legislator, the Senate, can just, no, forget it. We are supreme in our own obligation to try and decide. But ang punto, if there is grave abuse of discretion, diyan nakakapagsabi ang Korte Suprema, tigil niyo muna yan. But wala tayong nakukuha sa Korte Suprema because a TRO is normally issued once you file a case now, bukas lang may TRO na yan eh. Because what you only look at is the pleading, whether it is, substantial enough to warrant a TRO.
Dean Mel, pleasure to have you. Hope to speak to you again. Maraming salamat for sharing your insights. Thank you. To the former Dean of FEU Institute of Law, Attorney Mel Santa Maria. That's On Point. Join us again tomorrow, 7:30 p.m. here on BNC, the Billionaire News Channel. I'm Pinky Webb. Thank you for watching.